Did the President and the PSC have the power to create the present office of CAS in the manner in which it was created? 5. What are the financial implications of the creation of the office of CAS, and is it a waste of public funds contrary to Article 10 of the Constitution? 6. Was the President improperly enjoined as a party to the consolidated petition? 7. Who should pay the costs? We have also found that the following supplementary issues call for our determination. 1. What is the constitutionality of Section 26(2) of the SRC Act and the regulations thereunder? 2. Was the first interested party improperly joined as a party to the consolidated petition? 3. Was the consolidated petition drawn with sufficient precision? And 4. Should the court consider matters that were not properly pleaded? On the first issue, does the High Court have jurisdiction? We have considered the written submissions of counsel, as summarized above, together with the numerous authorities cited in support of the said preliminary objections, and the submissions of counsel, in particular the argument that the ELRC has unique competencies in the areas of employment and labor law, and that this court ought to defer to it on that basis. Respectfully, we find otherwise. Thus, a court of law can only exercise jurisdiction as conferred by the Constitution or other written law. It cannot arrogate to itself jurisdiction, except from the Constitution of Kenya. Article 165(3)(b) of the Constitution reads as follows, and I will not read out the entire clause because I know we are all familiar with it, but I will move forward and say that based on the law as set out above, and looking at the various issues raised in the consolidated petition, we are of the view that our mandate has been properly invoked. In particular, the consolidated petition raises numerous and weighty constitutional issues that go beyond employer and employee issues. The act constitutional in nature and call upon this court to interpret the Constitution as a whole in order to reach its conclusions in relation to the issues and relief sought. This exercise falls squarely within the confines of Article 165(3)(b) as set out above, and we find that this court is accordingly properly seized of jurisdiction. Based on our reasons as set out above, we find that the 1st and 31st of March 2023 are without merit and the same are dismissed. The next issue. Are any of the issues raised in the consolidated petition following consolidated reliefs in the consolidated petition? I will not read them all out, but our decision has summarized them all. I will go straight to the next part after that. Moving forward, all the parties prayed for costs, and the first to fourth petitioners prayed for any further reliefs that this court may deem fit. And all the parties are well aware that the present dispute has been the subject of litigation in two previous matters over much of the same subject matter, namely in Okia Umtata and another versus PSC and 73 others, and LSK versus the PSC and others in the Employment and Labor Relations Court conclusively, and reached various conclusions in relation to numerous issues that are presently before this court. Accordingly, several of the petitions by the said courts are accordingly res judicata. We are of the view that res judicata applies to a number of issues in the present consolidated petition, and which have been litigated at length and determined, albeit we do, however, note that LSK was the petitioner in petition number E.74 of 2022 and in the Employment and Labor Relations Court, and was also an interested party in the Okia decision, even if some of the parties to the present petition are different. Moreover, those issues ought to be res judicata on the basis that the issues in the present matter are more akin to issues in rem rather than issues in personam, because they affect a state of affairs and the society at large within the Republic, rather than purely private interests. We do not think that a court ought to relitigate the same issues over and over each time a new party files a petition relating to the same subject matter. To do so is an absurd outcome and embarrass the court with contradicting decisions. Having read the above said decision, this court notes that already the High Court and ELRC reached different conclusions in respect of a number of issues that were common to the two petitions. In order to avoid creating a third view in relation to the same issues, this court will treat some of those issues determined in the above cases as res judicata for the reason that they have been conclusively dealt with by a court of equal jurisdiction. That the judgment in Okia Supra is presently pending appeal in the Court of Appeal. That said, we note that the original office of CAS, established on 24th January 2018, and which was the subject matter in Okia, was abolished by the PSC on 21st September 2022. That was the office that was subject of the stay order in the Court of Appeal. One of the issues now raised in the consolidated petition is whether the new office, established by Gazette Notice 12th October 2022, is constitutional, and whether the complement of office holders appointed on the 16th March is lawful. Based on the above reading, we take the view that this court ought not pronounce itself on issues that are presently pending appeal before a higher court. We find that the following issues relating to relief sought in paragraphs B, C, and O, stated and listed above at para 189, are res judicata. We refer to the following paragraphs in the Okia decision in respect of the same. Issue B, namely, the office of CAS that the first respondent created are state offices, which can only be lawfully established and designated as state offices by national legislation, was dealt with at para 154 in the following terms. Having said so, it is without any doubt that the position of CAS in every ministry was finally created. These are senior government positions in the public service. The holders of such positions are state officers. There is no doubt that such positions have a significant impact on the National Compensation Bill. As said, the input of the SRC was mandatory. Further to the above, the court partly addressed the question of whether or not legislation is required to underpin the appointment process. The learned judge was particularly concerned with legislation for the purpose of approval of the candidate by the National Assembly and to enable public participation, as opposed to legislation intended to replace the appointment process. Quoting with approval the decision of our brother Justice Rika, the court referred to the appointment process relating to the managing director of the KPA and stated as follows. I will not read the entire quotation. I'll move forward and say, as regards issue C, relating to the role of the National Assembly in the appointment process, the court found as follows at paragraph 235. It is therefore the finding of this court that the persons who are appropriately appointed to the position of PS and CAS are only those who, 1. apply for such positions once the PSC advertised vacancies, 2. are shortlisted by the PSC, 3. are interviewed by the PSC, 4. are recommended for nomination for appointment by the PSC, 5. are nominated by the President for such positions, 6. are approved by the National Assembly, and 7. are appointed into the office of PS and CAS by the President. As regards issue K, in relation to whether or not His Excellency the President is bound by the recommendations of the Public Service Commission in the creation of an office in the public service under Article 132(4)(a) of the Constitution, at paragraphs 235 and 142, the court stated as follows. Again, I will not read out the quotation. We are therefore of the opinion that these said above stated issues ought to be excluded from our determination on the basis that the same are res judicata.